Joining me now is my guest for this hour, litigation trial attorney Rich Schoenstein, and former prosecutor and criminal defense attorney Marie Pereira is with me again. Great to see you guys. Thanks so much for joining me tonight. Truly appreciate it. Great to have you. I'm going to start off with you, Rich, and start with the Millete case, because I think it's important to stress that that case, to me, is really a circumstantial case. It's really about the, and just from the little bit I watched this morning, it's about things that Maya said about her relationship. I liken it to the Jensen case as well, that there was a lot of strife, a lot of problems. She was about to divorce him. She was talking to people about divorce, talked to that woman who worked at a firm that did divorce. Your thoughts on this preliminary hearing and the evidence that we've seen so far?
Well, Michael, I agree with you. It's a very circumstantial case because we talk a lot about cases where we don't have an eyewitness or we don't have a confession or we don't have DNA evidence. Here we don't have a body. We don't have a murder weapon. We don't have anything except the disappearance and the presumed death of this woman 2 years ago. And so the prosecution is building this case largely on motive, which is not always a necessary element of a murder case, but here it's going to be the compelling element, I think. They're trying to show that Maya was seeking a divorce. She was scared about seeking a divorce. The husband was trying to get in the way of a divorce, and that's going to be the prosecution's case for why this crime supposedly happened.
You know, Marie, we saw there a little bit of the testimony of Destiny Johnson, and there was an interesting issue that was raised that I want to get your thoughts on. The defense tried to claim that any of her testimony came under attorney-client privilege. She worked at a law firm. She was that intake person. Everyone knows that person. They're not an attorney, but they're the first person you talk to. You tell your story to, and they kind of direct you in the right way to go. And they were saying that it fell under attorney-client privilege, and she shouldn't be allowed to testify. The judge ultimately said, that's not the case, and she did, of course, testify.
An intake person is not an attorney, so it's not attorney-client privilege. And I think the conversation she had is very important. As Rich said, this is a case that's going to be really prosecuted by the prosecutor based on motive because a body may not be found. The fact is, she had a conversation with this woman, a clerk in the office, an intake clerk, and she talked about the future. So this whole defense that the husband is trying to plant as his defense, she just walked away from those kids. How are you walking away from your children when you're basing an appointment around a birthday party and you express the desire to be there for your children? Yeah. It is attacking that whole defense that they're planning.
Yeah, Rich, Marie is exactly right. I mean, at the end of the day, this is going to be a lot about the fact that because the claim by Larry Millete is that she walked out on them, that she had some other things going on, maybe even another relationship, and that she walked out on the family. But we're going to find out through her texts and her conversations with others that she really loved her family. The things she was most worried about were her children. We had this birthday party coming up right around the time of her disappearance, I think the next day after her disappearance. So that really is going to fly in the face of any kind of story that Larry Millete is going to want a jury to buy.
Yeah, I think it does. And I'm going to disagree just a tiny bit with Marie. Marie and I know each other very well. I think it might have been a privileged conversation because she was talking to an employee of the law firm about her appointment, about wanting to keep it a secret in the circumstances. But here's the important part, Michael. It's her privilege. It's not the husband's privilege. He can't assert her attorney-client privilege to keep out testimony that might be used against him when she is presumed dead. So even if it is privileged, and I think there's an argument it is, I don't see that objection working. I think this is going to come in.
Yeah, no, it absolutely will. It came in at the preliminary hearing. I think the judge was pretty clear it was going to come in at trial as well.